Thank you for joining Housen Johnson Insurance for another webinar. Today's webinar is titled Mental Stress Claims and Workers' Compensation, and it will be presented today by Peg Kramer. Before we begin, I would like to remind all attendees that we will be sending you the recording and the presentation slides after the webinar has finished. If you have any questions for Peg, you can submit your questions anytime in the questions feature of GoToWebinar's dashboard, and we will answer them at the Q&A session. And once the webinar is finished, you'll receive a survey. And the survey, we would love if you were to complete it and give us your feedback on how you enjoyed the webinar and other webinar topics that you would like to enjoy. And now I will hand it over to Peg Kramer to discuss mental stress claims and workers' compensation.
Thanks, Cassie. Good morning, everyone. I'm so glad we'll be together probably for 50, 60 minutes this morning. And I really encourage you to answer questions. I am a captive right now of your audience, and I would like to help you out on this topic that is unusual, but we do need to be aware of the exposure. And as an employer, I'm sure you think about the types of injuries that your employees may sustain in the course and scope of their employment. If you're an employer who has never had one of your employees injured, be very thankful because that is extremely rare. One type of injury that seems to cause concern and that many employers are not aware of is having employees file stress claims under workers' compensation. Yes, this is and can be a covered loss in Wisconsin. So I'd like to educate you a little bit today, talk with you, and hopefully you'll learn something, and maybe I'll learn something too. So I think we should start off by discussing the three types of stress claims that can be presented, and then an example of each one. So the first one is mental physical. This is where a stressful situation results in a physical injury. An example would be a heart attack. You witness a coworker getting crushed in a piece of equipment, and you suffer a heart attack witnessing the gruesome scene. The next type of stress claim that can be presented in Wisconsin is called the physical mental. And this is a mental condition resulting from a physical injury or disease. If you have an employee that would fall from a piece of equipment and fracture several bones, or in an auto accident, the fractures and injuries heal, but the injured worker is unable to come back to their job, go back into the piece of equipment they were running pre-injury. So what happens is that an injured employee, due to the mental anguish, is not able to return to his or her job. And the last type of claim that can be presented, and the one that is most challenging or controversial, is called mental harm or emotional stress or strain without physical injury or trauma. This would be one or more anxiety-type stress disorders. So an employee's job creates extraordinary stress as compared with coworkers who do the same job. Symptoms that would be presented would be panic attacks, anxiety, depression, fear, nervousness, apprehension, thoughts of suicide, and lack of commitment to their job. So when you lay out the definitions of these examples, when you think about it, these situations really aren't that rare, and I'm sure most of you can think about scenarios that you have heard either in your own workplace or from peers in your business. We do talk about and have for many decades about PTSD that veterans of wars experience, but persons who have never been in a war can also have that diagnosis as well. So we're going from the war zone to the work zone. What establishes these types of claims are considered compensable is based on cases that have been tried, and either not one, but it sets a criteria of what exactly the statutes do explain. And so when a case goes to a hearing and sets a precedent, it sets case law in Wisconsin for any type of claim, and then is published. So I'll giving you an example of case law that has been set in Wisconsin for each of the different types of stress claims that can be presented. I think the first two are self-explanatory, the mental physical and the physical mental. And they make sense where a physician, if the physician, based on the history, does award time off or says this is related to work, those are pretty clear cut. But for the third example, that really offers the chance for us to discuss and talk about the criterion that needs to be presented with that. And make sure if you have questions along the way, please submit them. So let's talk about one of the cases that set precedence in 1974. This is tested the mental stress claims, the mental in Wisconsin. So in 1974, a high school guidance counselor filed a workers' compensation claim after finding a list of recommendations from students asking for her removal from her position. As a result, she was eventually diagnosed with severe depressive reaction with anxiety. This claim or case went all the way to the Wisconsin Supreme Court and said that mental injury must have resulted from a situation of greater dimensions than the day-to-day emotional strain and tension which all employees must experience. Basically, in short, the guidance counselor did lose her case because, let's face it, high school kids are mean. They were mean in the 70s, and they're mean in this day and age. So this employee's claim did not rise to a level above the norm. So in Wisconsin, this is the extraordinary stress test, which must be met before a mental claim will be compensable. The vast majority of mental claims are denied and litigated later as to whether extraordinary stress occurs. In this instance, there is case law set, and it is Village of Brown Deer versus Department of Industry, Labor, and Human Relations, published in 1974. So let's talk a little bit further about the mental claim. Where the difference comes into play in this type of claim, they are very, very difficult to establish, and the injured worker must prove that his or her job produces the extraordinary stress as compared to their co-workers who do the same type of work or are in the same environment as their injured worker. Our own Wisconsin Supreme Court set the standards that mental injury is to have resulted from a situation of greater dimensions than the day-to-day emotional strain and tension which all employees must experience. Only if the fortuitous event, unexpected and unforeseen, can be said to be so out of the ordinary from the emotional strains and differences that the employers encounter daily without serious mental injury. So let's go a little bit deeper into using this extraordinary stress standard. You certainly must also consider and compare similarly situated employees. Okay, for instance, the bank teller, they have the exposure to be held up. When you take a job, you recognize that. It sounds maybe a little bit cruel, but that's a greater situation, as we hear about almost weekly, somewhere. We have, at least in the Madison area, at least every 2 weeks, we seem to have a bank robbery. So people in that situation are faced with that type of, or people that work in banks have that exposure. Construction workers, another example, who work in all types of terrain with dangerous equipment and they deal with extreme weather conditions, they too may experience fatalities or very horrible accidents that they witness. Another example is police and emergency care workers who deal with trauma on a daily basis versus an office worker who may not. Well, then again, think about the office shootings that we had a year ago in Middleton. An example of the stress standard is set with a case law set in 1989, Spink versus Farm Credit Services. And we also need to think about what is the true nature of the work stressor. Think about your employee's job description. Is what they do stressful in nature already? Think about working for the New York Stock Exchange. Could you handle all that noise and emotion, stress of being a day trader? That's just part of their job, and you know that going into it. Working in claims, I've worked in claims a long time. Claims people are exposed to clients that are not happy, agents who are not happy, and constant criticism of the work that they do. But, when you're hired, you're not hired to make people happy. You're hired to find the truth and pay benefits for the policies issued. So you know this ahead of time. Is it easier to file a claim when you work in a job that is predisposed to stress? No, not at all. Upset people, loud voices, swearing, threats are part of being a claims person. Now picture that environment for a yoga instructor. That type of behavior would not be normal. So if your employee has pre-existing psychological disorders or sensitive personality, they could claim they're unable to do their job. Each claim requires a thorough investigation and perhaps a medical opinion. An example further that discusses this and also set case law in 1996 is Brettel versus Labor and Industry Review Commission. So let's continue talking about the exposure of these claims. You need to also know something else about stress claims. In Wisconsin, there are two types of claims that can be presented, and they're classified as scheduled and non-scheduled. So what does that mean? What does that jargon mean? So an example of a scheduled injury would be a fractured arm, leg, hand, injury to shoulder and the hip. An example of a non-scheduled injury are injuries to the head, neck, and back. Stress claims fall into the head category, and these types of injuries bring additional benefits that injured employees may use if the claim is accepted as compensable or is going to be paid by the insurance carrier. And these types of injuries, the benefits that could be included with that claim, along with weekly benefits and medical payments, may include job placement, additional schooling for further education, and possible loss of earnings. Those are expenses that the insurance carrier would assume but can be certainly applied. And, of course, this catapults these types of claims into the six-figure arena very, very quickly. So in talking with employees and things that I have seen, not in my own workplace, but just in talking with fellow people and meeting with clients, here's some of the things that I came away with that employers tell me that their employees have or what they're stressing out about. What is the stress right now in the workplace? And I think there's quite a few. Number one, there's fears of being laid off in an uncertain economy. Or there's increased employer demands for overtime due to staff cutbacks, and that's a very real thing. We have job redundancy. Are you doing the same thing over and over again? You're not being challenged. Pressure to meet rising expectations without an increase in job satisfaction. Many employees do not feel safe physically or emotionally while they're working. And then relationships with coworkers are strained. Maybe they experience bullying and harassment from coworkers. So, in watching my adult daughter in the workplace, I always say it's not the work that you do. That you can learn to do that. I think the biggest thing is getting along with other people and accepting their quirks and their personality. People you work with, you're with the same people for a lot of hours, more so than your family. So you really have to make a concentrated effort to find the good in those people, but sometimes you can't, and sometimes you can be the result of those of being bullied or harassed. I kind of delved a little bit deeper into the bullying because that seems to be present not only in their schools but in the workplace as well as harassment. I found information on the subject that I wanted to share with you. Teresa Daniel, Dean and Professor of Human Resource Leadership Program in Louisville, Kentucky, has been researching bullying in the workplace since about 2005. She has said that it's crucial to distinguish between petty or uncivil conduct and bullying behavior, which is repeated mistreatment of an employee through the use of abusive conduct, threatening, humiliating, or intimidating behavior. Her research indicates that when employees feel threatened by their superiors, it can produce health issues for employees to include hypertension, heart attacks, sleeplessness, and thoughts of suicide or actual suicide. So what kind of boss are you? And I think you really need to take a serious look at that. And if you are in human resources or management, I think it's imperative that you look at your management role, the people that you have assigned to lead your company. Portland State University researched this very topic and released results earlier this month. This article concentrated on bosses who were bullied. In fact, in another study completed by the Workplace Bullying Institute in Bellingham, Washington, cites that 61% of bullies are bosses. Now that's crazy, and I had to read that a couple times before I got it. So being a bully, does that draw you to being a boss or the leader? I found that very, very interesting of the percentage. Bullying behaviors can cause severe stress and even contribute to accidents in the workplace. Stress in the workplace costs the U.S. economy $500 billion, and that 80% of workplace accidents could be attributed to stress from a 2014 study conducted by the American Psychological Association. Is there any questions so far? Okay, we'll continue. None so far. Remember, too, that if you or your management participates in any bullying behavior towards an employee, coworkers usually witness it. And remember that they make great witnesses for the defense of an injured employee on the stand in front of an administrative law judge. This type of behavior can affect workers at various levels. If you are a frontline supervisor and your upper management bullies you, you are more likely to bully the employees who report to you. So behavior begets behavior. I think this is one topic that you need to discuss with your management, staff. Human resources should be involved because that type of behavior of your management can lead to a stress claim, and in particular a mental claim, which, if accepted by the insurance company, can be a long-tailed exposure if someone has a psychological condition. Remember that management sets the culture in every business from manufacturing to education. You do need to be aware of the behavior that your staff may be exhibiting and what can occur because of it. So what can you do as the employer besides the obvious, being nice? I think, number one, recognize that these claims exist. One of my mottos is knowledge is power. And, be cognizant of when employees come in and talk, or you hear employees talk, whether it's in your own office or in a break room, and they might say, oh, I took a mental health day yesterday, or they complain of stress, or take time off as a result of work stress and let you know that. Don't blow them off. Pay attention to exactly what they say, because this may be a prelude to presenting a claim. And in your own defense that you built with your insurance company, if you had knowledge that this person was having an issue and did not report it on a timely basis, you can be held as an employer in bad faith. So I think one of the takeaways, I think the most important takeaway that I do talk about with clients when I travel is that you need to learn when you may have an obligation to report a stress claim to your work comp carrier. You can always have conversations with your agent. You can have conversations with your adjuster if you have an assigned adjuster from your insurance company that handles your workers' compensation claim. It's always good to run scenarios by the people that deal with this on a daily basis. And I feel that the most important takeaway from this discussion is this. If you have an employee who comes to you and says, I want to present a stress claim as related to work, you, the employer, need to take the information and file a claim as soon as possible and submit to your work comp carrier for a complete investigation. I would strongly suggest that you do this within 24 hours of receiving this information, especially if they have presented any medical documentation authorizing lost time, indicating that their current symptoms are related to work. Once again, if you do not, you can be held in bad faith as the employer. Also, an opportunity may arise and tip you off to a claim is that if an employee files FML papers indicating work stress is the cause of filing FMLA, and if it has contributed to their employee's condition, even a pre-existing condition, and resulting in need for time off of work, this gives you a big red flag to certainly talk with frontline supervisors and management that handle the claims at your company, that indeed a work comp claim should be filed in conjunction with an FMLA claim. And specifically, if they bring actual medical documentation in immediately. So that I really feel is time of the essence. And the sooner that you're able to tip your insurance carrier off, the better investigation, that they can do for you. It doesn't do any good to hold the information for 6 months and then submit it, and the insurance carrier's behind the ball. They really can't do a good job for you, and I think it's very unfair to expect them to do so. Your best bet is to work in tandem with your insurance company and your agent if you have questions or are unsure about the scenario. I think when in doubt, submit a claim, and the insurance company would be happy to work with you. And they will let you know the documents that they need from you to process the claim or to do an investigation. So other than that, does anyone have any questions about situations like this, scenarios, situations they've been through, claims that you have filed for employees that were accepted? I would love to hear about that.
Now we're going to open it up to our question and answer section. If you look to the bottom left corner, I have also put the HRCI and SHRM credit codes for you if you need them. And so now we'll start. The first question is, how can we work to get an employee back to work after a stress claim? Is it different than a physical claim?
Not really. Return to work is the best thing that any injured employee can do. I think having a good communication with the treating practitioner, making sure that the individual, and this would be on the insurance companies end, working very closely with the adjuster to make sure that there is a defined medical treatment plan for that individual with their treating practitioner, whether it's their general doctor or a psychologist or a psychiatrist. You want to get that person back in the workplace, maybe temporarily at some other type of duty. But I still feel returning to work, even if it is a stressor, makes everybody kind of sit up and think about, how could we handle this situation better? How can we welcome this person back into the workplace? What do we need to accommodate them to get back to work? And the work, accommodating in its own self is the key to getting anybody back to work. So just making everybody aware of the obligations under the law and working with the doctor on getting, sometimes they'll return an injured employee, whether it's a physical or mental injury, to starting out to a few hours a day and gradually progressing to full-time work. And that would help mitigate the loss as well.
All right, so now we're going to discuss a situation. So there was a situation for an employer where an office worker had an experience where a customer got angry and said they were going to come back with a gun. Thank goodness they did not come back, but the staff member was very upset and ended up needing to leave due to the stress. Would this fall into a type of situation as a mental claim? The individual does deal with customers that can be angry at times, but a threat of violence such as this is not standard.
That is a very good question. We talked about the extraordinary stress test, and that would be disturbing if I went through that. I think if that's not the norm in your situation, as we now see office shootings, school shootings are more prevalent than ever. Our country is becoming very violent. I think definitely, well, first of all, for any claim to be compensable, medical treatment has to be sought. So if that individual went home, that's understandable, but they only can file a claim if they seek medical treatment. So please remember that.
All right, keep those questions coming. All right, how do you know whether you should file a stress claim or refer an employee to an employee assistance program, otherwise known as an EAP, or should you do both?
That is a good question. Yes, definitely refer to EAP, which is a great resource for any company. And at the same time, yes, file a claim for the insurance company to do an investigation. And why I say that is that you pay a lot of premium for your work comp product, and adjusters are trained specifically to, they may take a statement from that person, they may do it in person or over the phone, and that encompasses exactly what they're alleging, but also entails their background, what is going on in their personal life. I know years ago when I was on the road and I worked for Wausau Insurance Companies, we had stress claims. I would go to people's homes and talk with them, and many times there's always something else. There's usually something else very traumatic going on in the home versus being work-related. And because what we experience at home can certainly play into your work life, whether you have a pre-existing condition or not. So the work comp carrier not only does recorded statements or statements, they get medical authorizations to get prior notes if this person has had pre-existing conditions with a medical authorization. When a person files a claim, you waive your right to privacy to HIPAA law, and so adjusters are able to get current medical treatment plan and records when they file a claim that a medical authorization is not needed. They also talk to coworkers. They talk to supervisors. They talk to supervisors. So they really delve deep into whether or not this is a compensable claim. And, they go as far as they can with the information to make a determination, and usually the facts speak for themselves. Maybe you do have a boss that's absolutely horrible, but he's only signaling a certain employee out. That's very, very dangerous behavior, and could make, for a very ripe claim. So the insurance carrier knows exactly what to do. I always strongly advise you good clients to give your full cooperation when a work comp claim is presented, whether it's for stress or other types of claims. You need to be very intimate with your insurance carrier so that they can do the proper job on your behalf. And that's what they do. That's why you pay the big bucks. So let them do their job, but they only can be as good as what you share with them. And if you're not sure, ask them. I'm not sure I should be telling you this, but this is, I have some concerns. So many times when people have non-work related issues at work or at home, they certainly can bring them into the workplace, and they do cross the streams. So
very good answer, Peg. The next question is, if HR notices a potential stress claim, whether it be a merger, new leaders, or new processes, am I required to suggest they put in a workers' comp claim?
I did read, that is very good. I did read in some of the research that I looked at, that type of situation is not grounds for a stress claim. And I think that's because and I looked at that and I thought, gosh, I would think that'd be very stressful. But that in and of itself is not enough to make a claim, because most times other people, not just yourself, is going through that situation. Now, the situation may be unique if it is happening just to one person. But job changes and changes in leadership and management aren't always enough to be the catalyst for a claim to be accepted. And that certainly would have to be investigated to see the exact circumstances, what are going on. But that is one of the situations that I read about. So that definitely is one you'd want to investigate.
All right, the next question is, if a stress claim is accepted and paid by our insurance carrier, will that affect our premiums the same as a physical claim?
Well, most definitely. And that's why I talked about the two different claims in Wisconsin, the scheduled and unscheduled. Anytime you have a stress claim presented, it can go into that unscheduled category of injuries, which include extra benefits that somebody that has a broken arm at your facility does not receive. Stress claims, if a claim is accepted and this person treats for quite a long period of time, or they can't come back into the workplace, your insurance carrier may be looking at placing that person in another job in your facility or job placement away from your company. Schooling, additional schooling might be needed. And then if they come out and they're making less than needed for you, loss of earnings. So these, the cash register really starts ringing up when claims like this are presented if they are accepted. So yes, it's going to affect your premium. Anytime lost time indemnity benefits are being paid, that's what drives up your experience mod and your premium, your charge for your premium. So yes, they definitely count, as your claim history.
Any more questions? Peg has a wealth of knowledge on this stuff. She deals with it every day.
And I do want to add that to dovetail that discussion, and that was a very good question about the claims that affect your experience mod. Not only if a claim is presented where lost time is paid, that claim affects you in your work history for 3, sometimes almost 4 years. So anytime a claim that is paid for lost time is affecting you not only for that current, not for the current term, but for the following 3 policy terms, it affects you and your experience rating.
And if you could go over just a brief recap, Peg, of the mental claims.
Sure.
And as well the scheduled, unscheduled.
Sure. The mental claim is mental harm or emotional stress or strain without a physical injury or trauma. This would be one or more anxiety-type stress disorders where an employee's job creates extraordinary stress as compared with coworkers who do the same job. Symptoms that would be presented could be panic attacks, anxiety, depression, fear, nervousness, apprehension, thoughts of suicide, lack of commitment to their job. So if you have a group of employees that are all in a very stressful situation, and that's just the norm because they have deadlines or the nature of their job is very stressful, that alone is not enough criteria for a claim to be accepted as a mental. I certainly, if you have questions, I certainly would suggest you strongly file that with your work comp carrier and let them do their investigation. But it has to be a situation where maybe perhaps one of those people in that stressful situation is being sought out, being bullied or harassed by their supervisor or their boss. It has to be extraordinary of the people that you are with, your homies, the people that you work with every day. Are you all under the same stress pattern, or does someone pick on you specifically from management, or are you set apart and have to do extra duties that the other coworkers aren't doing? So we're talking about the job situation and your situation with among your peers. And I hope that answers that. If not, I can certainly go into that as well. And we talked about scheduled and unscheduled injuries, and that is weird jargon. But in Wisconsin, when someone breaks, I guess I'm thinking about when I was a kid, and my neighbor boy always broke his arm every spring, and he was in a cast for like 6 months. So when we talk about scheduled and unscheduled injuries to me are your appendages, arms, hands, fingers. They also go into the hip and the shoulder, areas that there's a set amount of time that they usually heal. but like with a back injury, a neck injury, a closed head injury, those are types of injuries that you really don't know how they're going to heal with an individual. And if they lead to such a permanent injury that that person can't come back to the regular job, that's where the unscheduled injury benefits come into play. So if somebody has a closed head injury, they can't come back to the regular job, maybe the insurance carrier has to find a job for them at another place of employment or send them to school for retraining. And while they send them to school, they pay them actual benefits to go to school, like when they're off of work. So people can be sent to a 2-year program, and for 9 months they receive weekly workers' compensation benefits. Their tuition is paid, their meals and mileage is paid, their books are paid. And then if they come out and they're not making the same salary that they made at the pre-injury state, you and the insurance carrier may be liable for loss of earnings. So there's a great difference of benefits afforded with unscheduled injuries versus scheduled.
And this is a claim/FMLA question. So if a person applies for FMLA and said they are very stressed but doesn't specifically say it should be workers' compensation, should you process it as workers' comp as well due to this situation, or should you just run it as FMLA?
That's very good. When I deal I work with our human resource department here very closely, and we have 3 individuals that are awesome at what they do. I look at it this way: if most people file a work comp claim, they should be filing FMLA as well concurrently. Yes, definitely file the FMLA, then have a further conversation because they're going to need to supply medical information for the FMLA claim. I think that needs to be a further discussion with human resources, and you can ask for them to present documentation or have a further conversation. Just say, look, may I ask what the nature of this is? You'd rather have the information sooner than later. So very, very good question. When in doubt, talk with them further.
What about a situation where employees are covering extra workload, perhaps because another employee has been out on a medical leave or something similar? Would this added stress be enough to file a claim?
That's a really good question, Cindy. That situation came up in the research that I was doing as well. I think a lot of it depends on how long. We talked about staff cutbacks, employers doing more, with less people. I think it depends on the job that person that is out of medical leave does. Are people cross-trained? Is it just for a short period of time? I think, once again, if you're asking them to do a totally different job that they're not trained for and don't have significant backup, are you telling them they have to do overtime? Are you demanding that they do overtime? I think that type of situation, and if they're seeking medical treatment for stress, that could end up being a claim. But certainly an investigator would need to be talking to your employee that presents the claim and find out the situation, just exactly what is being required by you, the employer, on your end. That's not a black or white answer, really. But more information, would have to be certainly, like I said, are they trained to do that job? Do they need extra training? How long is that person going to be out? So that could lead to a claim.
Just to follow up with that, Peg, so would it depend on the type of documentation that employee presents for filing the claim?
Yes, definitely. Once again, to file any type of claim, you have to have medical treatment. And one thing that is a little scary for you as the employer, when we're dealing with mental health professionals, it's very hard and very private. But once again, sometimes we have those medical providers that will not release medical records because it is such a private situation. Once again, employees file a claim, HIPAA laws are waived, and the insurance carrier has the right to that documentation. And if the documentation isn't clear about this being work-related, then the adjuster needs to get on the phone with that treating practitioner or demand a clarification. And sometimes if that's not being provided, then benefits don't have to be paid. It has to be clearly stated by a medical professional what the diagnosis is and what the cause. And if they don't know, then the insurance company might do a medical records review or an independent medical exam of their own to clarify, is the stress your employee is under at this time related to their work or a result of their work?
All right, here is another situation for you. What if someone had a back or neck injury and has been out until they cannot come to work now since they are close to retirement, but they don't qualify because they haven't reached the age or years requirement within the company? The person said they can't return due to mental and physical stress, so they can't finish the remaining few years. Would the workers' comp cover their other benefits for the mental stress of them not being able to return, such as retiree benefits?
No, workers' comp wouldn't cover that. That's totally separate. Workers' comp basically only covers your lost time from work if you're authorized off of work, and that's 2/3, your medical bills and your mileage, prescriptions as well. And once again, even though the employee is making that claim, they have to have that backed up by a medical physician. And in fact, insurance carriers won't pay weekly lost time benefits unless they have in writing the return to work or what their medical status is. So that employee has to provide that every time they are seen by their practitioner, whether it's a psychologist, psychiatrist. They have to present that I was seen by Dr. Jones today. Here's my diagnosis. I'm not, Joe or Jane can't go back to work because of this, this, and this. So they can't just expect that work comp is going to pay any of their retired benefits, because sooner or later you have to, employees and a doctor has to declare what's called MMI, or medical maximum healing. This person has plateaued and is going to be the best that they're ever going to be. And that is a dangerous situation, because it sounds like this employee, would like to finish her career or retire with work comp benefits. So, and some people do. Some people say, well, I'll never go back to work because of this. And that is a very tricky situation, especially if they're facing retirement. I would think in that instance, a medical opinion with a qualified psychologist or neuropsychologist or psychiatrist to examine that person to see just exactly where they're at. Some people, that's their goal. Instead of retirement, I'm going to go out on workers' comp, and I'm still going to get workers' comp, or at least my medical bill's paid till I pass away. So you have to be careful about that situation, and it has to be backed up by a medical opinion.
Is that a common situation to have retiree benefits coincide sometimes with a mental health claim?
Well, yes. People in Wisconsin, well, nationwide under Medicare, what's called a Medicare set-aside is that if people are the age to qualify, so it'd be 62 and older and above, if they qualify for Medicare and they're on an active workers' compensation claim, before that claim can be settled, the insurance carrier has to contact a firm, CMS, and obtain what's called a Medicare set-aside, especially any claims that have a value of $25,000 or more. That is a long process, but you're actually petitioning Medicare saying, look, I have a bad back. I'm going to retire. I don't want Medicare, and Medicare doesn't want to pay for my work comp claim. So what do you think for the rest of my life it's going to cost with my diagnosis, my age? And they may come back and say, you owe nothing, or, hey, insurance company, you've got to set aside $100,000 for this individual for medical benefits until death, because it's not fair for Medicare to pay for someone's medical treatment if they've been injured on the job, and that's called a Medicare set-aside.
All right, we've reached the 45-minute marker. I would like to do a final call for questions before we end the webinar. Let me know if there's anything you think of and put it in the questions feature. Otherwise, if you think of something after the webinar has ended, feel free to reach out to us and we will be able to get you in contact with Peg, the speaker.
Yes, if you have any questions, you can call me directly. My phone here at Hausman-Johnson is 608-252-9604. That's 608-252-9604. I'd love to hear from you. You don't have to be a client of Hausman-Johnson. If I can help you out in any way, I certainly would, or provide you with documentation or point you to the appropriate area. But these claims are very unique, but they are real, and I want you to be aware of that. Majority are not work-related, but if they are, then you have a very serious claim on your hands that may be open for quite some time. They have a long tail exposure, meaning, benefits could go on, for years if the claim is so severe. So please take them seriously and call us if you have questions.
All right, and with that, I believe we will conclude the webinar. If you would like to join us on October 24th, our next webinar will be called Ditch the Performance View, Then What? And we'd love to have you join us. Remember to fill out the survey, and as a reminder, you will be getting a copy of the slides and a link to the recording of the webinar as well. Let us know how you felt about it in the survey, and thank you for joining us today.
Thank you, everybody.